Now, we'll go back to our earlier story with regards to Anas and Kennedy Agyapong. Now, we are joined by private legal practitioner Theophilus Donkors to give us more insight on that. Good evening and welcome to this night, sir. Many have questioned the outcome of this report, but can you give us certain fundamental issues about the style of Anas? And are you able to explain how the court probably got to this conclusion in the case?
So, in defamation cases, what the plaintiff will have to prove is that there's a publication or something is said about him that he feels that it has reduced his reputation in the eyes of the right-thinking members of the society. But the defendant also has a defense, and one of the defense available to the defendant is justification. He has to provide evidence that whatever he said, he needs to justify that based on A, B, C, D. That is why I said this. So from my reading of what has been put out by Tiger PI, what they are beef or what they are worried about is that the judge came to a conclusion that who watches the watchman, Kennedy Agyapong put out, was a justification. And justification in defamation cases is a good defense. So if the judge has accepted the justification which Honorable Kennedy Agyapong put up, then it means that from what my reading of the judgment or what has been put out means that I don't think that the judge did anything wrong. If he found out that whatever Kennedy Agyapong did or whatever Kennedy Agyapong put out there was a good justification for whatever he did, then I think that the judge was right.
In the judgment, the court says Anas's modus operandi is against the law. In fact, the court describes it as investigative terrorism. This is a style the president himself of the Republic had once said he will use when voted into power. Does this strike any thought in your mind?
I think that at the top of my mind, I agreed with the judge, and I will explain. If you entrap me, if you know that Theophilus Donkors, I like cigarettes, and you come to me and you give me cigarettes, and I take it, based on that, you say that because I have taken cigarettes, I'll be influenced or the cigarettes will influence me, and you come out there and say that this is what I have done, so they should deal with me. I think it is not right. In law, it is called entrapment. If you entrap somebody, you allow the person to be in his or her natural environment so that you act reasonably. But if you influence the person, you realize that if you look at the judge's case, some of them, the money was not given to them. It was left on their table. So if you leave the money and you capture it on a video and you leave, what shows that the judge took the money or the money actually got to the judge? So I think that I agree with the judge, the position of the judge. If you know that a man likes fair women and you entrap that man with fair women, definitely he's going to fall for it. But I believe that the law requires that the way we behave in our natural environment is what we should be used to judge us, and not to entice somebody or to induce somebody to commit a crime and you turn around and say that this modus operandi. I think that I agree with the judge. Some of us have not believed in the honest way of doing things. Okay. We believe that if you want to fight corruption, you should allow the people to be in their natural environment, the way they work.
All right, lawyer.
They should not be induced.
Lawyer, I want to understand something. Initially, there was a case that involved Winston Tackie. At this point where this ruling has come out, can he clear his name? And a follow-up also, Anas has described the ruling as a travesty of justice. What do you make of that as well?
I think that will be unfair to the judiciary. The issues he has raised in his letter, I think that Anas has not shown good faith. Because this same judiciary has relied on your evidence, has relied on your modus operandi to convict people, to dismiss judges, and to also go ahead to say that because the case has gone through the hands of 3 judges. There are instances where if a judge is transferred from Accra to Tamale, or there's an incident, the judge has been promoted, for which reason he has been moved from that court to another court. The Chief Justice has the power to assign judges. And if at the time Justice Eric Ban was assigned to conduct that case, if you had any issue with him sitting on the case, or if he has shown any level of bias, he could have raised it and even go to the Supreme Court to have him prohibited based on his conduct of the case. So I think that for us to be blaming the judiciary at this time, I think it is unfair. It is an attack on the whole judiciary, which a lawyer should not be allowed to put out that statement. If he feels that he's aggrieved by the decision of the High Court, he can appeal to the Court of Appeal. So he should be telling us that he has filed based on this and that grounds. But to be attacking the judge is attack on the whole judiciary. And I will explain to you, your viewers.
Okay.
What it is that all of us, when we have an issue, we go to the judiciary for it to be resolved. So the judiciary is our last resort. It's our last hope. So if you announce you have been going to court and you've had judgment against other people, and this same judiciary has decided the case at the High Court, and you know as a lawyer that you can appeal to the Court of Appeal, to the Supreme Court, and even after the Supreme Court, you can apply for a review. For you to be turned around and be attacking the judiciary or to be attacking the judge, I think it's unfair, it's unwarranted. We should be condemned by all